Hi everyone, I am Sharda Mani, Assistant Professor, Department of Commerce. Today we discussed about case study on the basis of the amalgamation. Okay, let's see. Amalgamation refers to the legal process of combining two or more companies in a single entity. It involving the merger of asset, liability, and operation of the amalgamating companies to from a new company or merger them into an existing company. The Companies Act 2013 provides a comprehensive framework for the process preliminary under Section 230 and 232 and the Section 233. Okay, the types of amalgamation inroads into two types. The first one is regular route and the second one is fast track route. In regular route, the section 230 232 is full of NCLT approval required, and the the company is mandatory for the cross border mergers. The second one is fast track route. The section is 233. There is no NCLT approval unless referred the small company startup holding a wholly owned subsidiary and now inbound reverse mergers. The first in that fast track amalgamation is section 233 provides an expenditural process for certain classes of the companies without NCLT involvement. It is the eligible category of two or more companies, two or more startup companies between a holding company and its wholly owned subsidiary, between a foreign holding company and a Indian wholly owned subsidiary. It is a small company means the paid up shares are 4 crores, turnover 40 crores. The fast track process requirement is notice of a proposed scheme inviting objectives, suggestion issued to the registrar, official liquidators and affidavit persons. It is approved by the shareholders holding at least 90% of the total shares in general meeting. The declaration of the solvency filled with registered by a company, each company. The approved by creditors representing 9 tenths in values, that is 90%. Transfer of the company files approved schemes with the central government, register and the official regulators. It is the approval processes if register and official regulator raise no objective within 30 days, central government and register the scheme of and issue confirmation. If the objections exist, the central government may fill application before NCLT within 60 days. Registration scheme of results is dissolution of a transferable company without winding up the process. The recent amendment is the fast track of for inbound cross-border mergers. The Companies Amendment Rules 2024 effective on September 17, 2024. The key provision is a foreign holding company can merge with its Indian wholly owned subsidiaries. The conditions are prior RBI approval required for both companies. The transferee Indian company must compile with section 233. Declaration required if the foreign company is incorporated abroad and the shorting company. Application made by the transferee by the Indian government, and it promotes the reverse slip structure. Companies that originally set up the holding entitles overseas can now reallocated partner entitled back to the more efficiency. Okay, the regular route amalgamation, it is companies not eligible for fast track must follow the regular of the NTCL route. The main key feature is application filled with NTCL having a gesture over registered officers. The public interest and creditors interest are paramount considerations. So let's see how they explain in the case study.
Hello everyone, we are currently pursuing our BCom degree in Business and Listing College of Commerce Design. We are here to explain about secondary case solution for amalgamation. Myself Monisha, I am meeting with sir.
Myself
Myself Namrashni, Sarita. Introduction. Amalgamation means the combination of two or more companies into a single new company. The purpose is to strengthen business operation, increase market share and improve efficiency. In this case, two companies facing challenges decided to merge to create a stronger organization.
Amalgamation. Amalgamation is chosen because it allows both companies to integrate their reasons, technologies and market networks.
Prototype implementation steps to implement amalgamation. Agreement between both companies. Valuation of assets and liabilities. Approval from shareholders and regulatory authorities. Formation of a new company combining both businesses. Integration of employees, technology and